Hi, everyone. I see we have about 10 people. Thank you for joining me. I'm going to just wait about a minute or so before I get started to see if anybody else gets here a little late, understandably. And other than that, we will get moving. Okay, I don't know if I'll have to let people in as we go along, but if I do, I'll try not to get thrown off track. Um, My name is Sarah Paris Torville. As you can see, you should be seeing the Morneau Law sign from my slideshow here. There's a picture of our actual location there. If anybody could actually just do something in the Q&A to confirm that you can hear me right now. I did unmute, but um, I, I hope I'm not just a talking face at this point that um, okay, great. I got confirmation that audio is good. Perfect. Okay, so as I said, I'm Sarah Paris Torville. I am New Hampshire born and raised. I graduated from Pinkerton Academy in Derry. Um, I grew up in Wyndham, and I was part of the last Wyndham class to go to Pinkerton, which probably gives you some idea of my age if you know that. Um, I went to UMass Lowell. So for a little bit, I temporarily lived outside of New Hampshire in Massachusetts. I got my undergraduate, I got a BS in criminal justice and a BA in psychology. And I then went to, it was Franklin Pierce Law School when I entered it, but it's now been taken over by UNH and they call it Franklin Pierce School of Law. And I graduated from there in 2005 and I have been practicing. I've been admitted to the bar since 2006. So I am currently a Derry resident and I've been married. I've been with my husband for 20 years and I have a 15-year-old, soon to be 16-year-old son and a 12-year-old daughter. So for those of you with teens, I salute you. Um, we will get through this, is what I heard. This is my first time doing a webinar, so bear with me. Hopefully, I have already sussed out any technical difficulties I might have. And in the meantime, I will be picturing everybody attentively listening and smiling at the camera that I can't see. I'm just kidding. You probably are all on your phones, and I accept that because sometimes it's easier to learn things when you are comfortable and slightly distracted, but able to listen. So with that, I will give the standard disclaimer. It was on the sign up for this, so you would have read it, but I am a lawyer, so I do have to say it out loud. This is an estate planning webinar. It's for general informational purposes only and does not constitute legal advice. Participation does not create an attorney-client relationship. Questions will be limited to general topics covered and will not address specific individual circumstances. For advice regarding your situation, please consult a qualified attorney. So that brings me to the Q&A. I don't know if you know how to use the option, but there is a quick Q&A option here. I'm going to be stopping in the middle of the presentation to look at questions. And what I want to direct you to do is I'm going to be going through lifetime documents in the first part of the presentation, and then I will be doing distribution documents in the second half. So when you think of questions, I'd say put them in the Q&A, but maybe don't send them yet. Try to keep them relevant to what I'm talking about. And if I haven't answered your question by the time we get to the Q&A, then send it and I will answer your question. But a lot of stuff I might actually get to and answer your question ahead of time. So I'm going to get moving with the slideshow. And I'm going to talk, oh, well, this is me. This is my introduction. And so, as it says, I'm a trust and estate planning attorney with a deep commitment to guiding individuals and families through what can be an overwhelming legal process. I do believe that thoughtful estate planning is one of the most meaningful gifts you can give to yourself and to your loved ones. So with that, what is estate planning? So I don't like the term estate planning at all. I feel like it is a misnomer of sorts, because you don't need an estate to do estate planning. You just need to be alive to be doing estate planning. So I have decided, until I come up with a better way to phrase it, I'm going to call it what if planning, because that's really what estate planning is for. It's what if this happens? What's going to happen? How have I prepared for that? So estate planning as a guide. It's a roadmap for your loved ones, and it gives them the legal power to do the things they need to do to either help you or to take care of your wishes afterwards. Most of my estate planning is focused on avoiding court, with the exception of wills. And these documents, although there is an upfront cost, it is going to save you money in the long run by avoiding the court process, which can have significant costs. I discuss things like agent consideration for different roles, and I would provide guidance to you if we met to discuss whether or not a certain person would be a good agent. It's something that we, would discuss in a meeting, but that's part of a thing that you think about when you're doing estate planning. And it's a complete plan, so it fits together like a puzzle. So all the pieces, like I said, there's lifetime documents and there's distribution documents. And when you have all of that, you've kind of got everything covered. Why do you want to do estate planning? Or, as I like to say, what if planning? Protecting your loved ones and easing their burden. So that's for after you're gone. By having a will or a trust in place, you are able to protect things for your loved ones and make it easier for them because you've set things up for them. You ensure your wishes are clearly carried out during your lifetime and after, because the lifetime documents help you to appoint the person that you know will take care of things the way you want them to. And you will pick somebody who is going to take care of things and follow your guidance in your distribution documents afterwards. As I said, it's also there to avoid unnecessary costs, delays, and with the exception of a will, it avoids probate complications. A good plan is going to minimize family conflicts and misunderstandings, because not everybody wants to talk to their family about what their plan is, but by having a good plan in place, it will be clear what you wanted. One of the things that is important in estate planning is addressing your unique family. And there are many families that are blended, and their first marriages and second marriages and children from a prior marriage. And all of those things need to be addressed when you're doing an estate plan. Another thing, if you have a business, you're going to want to incorporate your business into your overall plan. So you could have some succession planning, but you want to tie that into your estate plan. If you have charitable giving wishes, then that's something that you would do through the estate planning process. And another really important thing that we do at Morneau Law is we provide planning for people with special needs. And that's a particularly complicated area that needs to be done very carefully. So those are the reasons why estate planning matters. So estate planning, or what if planning, is going to have two sets of documents. There's going to be lifetime documents and there's going to be distribution documents. Oftentimes you'll hear those distribution documents referred to as dispositive documents, but I also find that a pretty unapproachable term. So I use distribution. The key documents in a basic estate plan, the lifetime documents, are going to include a power of attorney for healthcare, We do an additional HIPAA form and a power of attorney for finances. The distribution documents are, most people think about the will, but the other thing that a lot of people should consider is a trust and the documents that go along with the trust. There's ancillary documents when you do a trust that you'll need to make the trust fully effective. So first, let's talk about lifetime documents. Nobody actually seems to be interested in talking about lifetime documents when they come to see me, but they're the first things you're going to need. So I always like to cover them, and I cover them first because chronologically, that's when you're going to need them. If you don't have those powers of attorney that I just went over, your loved ones are likely going to need to go to court to gain legal authority to make either medical or financial decisions for you. So that's where the cost savings comes in. If somebody goes to court to get a guardianship, oftentimes they will hire an attorney to help them through that process, because you need to be able to figure out how to get through the court process. And a lot of people need assistance with that because it's not necessarily user friendly. So the first lifetime documents that I talk about that are really important are your medical documents. So we do something called an advance directive. In that advance directive, there's two separate documents really that are the healthcare power of attorney and the living will. A healthcare power of attorney is what it sounds like. It's where you're going to appoint an agent to make your medical decisions for you. It is only going to be used and activated upon your incapacity. I call it a springing document. It springs into action when you're out of action. It's not to be used before then. A doctor has to deem you incapacitated. So nobody makes your medical decisions if you are able to do that yourself. The living will almost always goes along with the healthcare power of attorney, and it's really there for guidance for your agents and the doctors to know one main thing, which is what you want with regard to life-sustaining treatment. There's two choices in a living will. A is the first choice, and it is you want life-sustaining treatment given to you no matter what. You want to be kept alive, and you don't care what the costs are. Most people do not want that. And so really this document is often there to clarify that you would rather have B, which is that life-sustaining treatment not be used if it's excessively burdensome or it has no reasonable hope of benefit. So in those circumstances, I have had people that would prefer to be kept alive no matter what. But most people want to make sure that their agent has the authority and the guidance that they don't want every last thing to be done. The other document that we do at our office is a HIPAA authorization, and this one's just to allow your loved ones, and we usually name the people that your agents are agents in your healthcare power of attorney, to access your medical records. They will have that ability when the healthcare power of attorney kicks in. If you're incapacitated, they'll have access. This allows access prior to that point. So if you want somebody to be able to coordinate with your doctors before you become incapacitated, this document is what you would give to your doctors. But you wouldn't give it out unless you really wanted those people to be able to talk to the doctors, either on your behalf or in coordination with you. So there is a surrogacy statute. This is there when your agents and your healthcare power of attorney are not available, or you don't have a healthcare power of attorney. So it allows doctors to appoint a surrogate on your behalf to make your medical decisions for a short-term period of time. It used to be a maximum of 90 days. It now will go up to 180 days, which is quite a length of time. But after that 180 days, if you're still incapacitated, somebody will have to go to court to get a guardianship over you. This statute is going to outline the order in which doctors are going to pick a surrogate. So this shows that the first choice they will have is your spouse, unless you're in the process of getting a divorce. The adult children, if there's more than one, they're going to look toward a majority of them. Parents, if the children are not available, then adult siblings, after that an adult grandchild, after that a grandparent, then we go to aunts, uncles, nieces, and nephews, and it will all go all the way to a close friend. So in our healthcare power of attorney, we have a place where you can object to that, but most people don't want to object to a doctor being able to make a surrogate, because that means that in order to make your medical decisions, somebody has to go to court to make those medical decisions on your behalf. So financial documents. This really is one main document. I call it a durable power of attorney for financial matters. Oftentimes you'll see it referred to as a durable general power of attorney. And this is going to appoint, like the healthcare power of attorney, an agent, also referred to as an attorney in fact, to be able to take care of your financial assets. The difference between the healthcare power of attorney and this is usually your financial power of attorney is effective immediately. It's what I generally recommend. You can make it springing. And the reason that I don't recommend that you make it springing, which means the financial power of attorney is only used when you're incapacitated, is banks are the ones that are usually dealing with these documents, and some of them are particularly picky about how these documents are laid out. And if there's a provision that says only if I've been deemed incapacitated, and sometimes it will give a description of what that means, it might be difficult to meet those requirements that you set out in the document, or you might meet them and the bank doesn't think you have. So it leaves it up to more difficulty. The protection that you use from this being misused is picking the right agent. If you have a concern about somebody, you shouldn't appoint them as your agent. The reason it is called general is because it's general. It's usually going to be a general power of attorney. And in ours, we list basically everything that you can do financially is what you're allowing people to do in your financial power of attorney. We don't want it to be missing a power, because if it's missing a power that you need outlined in there, then we're back to guardianship. You can make a limited one, and sometimes people do. And in that case, a common one is like a limited power of attorney for real estate. Sometimes people will appoint somebody just to do a real estate closing on their behalf. So in that instance, you wouldn't need a full power of attorney. And they're usually kind of done throughout that process. But most people, when they come to me, are coming for a general power of attorney. It is durable, and that means it remains effective upon your incapacity. That is actually something that seems to go without saying, because why would you need a power of attorney if why you would need it upon your incapacity is what most people think. However, I don't think it was often used like that. Historically speaking, it was used as a convenience purpose to allow somebody to make financial movements on your behalf. And if you were incapacitated, they say, well, they might not want that anymore. Well, we now make it so that you state it in the power of attorney, and you must state that it is durable and it will remain in effect. Okay, so we are at the halfway point. If anybody has questions, I'm going to look in the Q&A. I don't think anything has popped up, but I will take a look. Oh, nope, just some comments that you can hear me, so that's good. And I don't see any questions. If you have any as we go along, please feel free to pop them in there. And I will take more time at the end of this to check in on any other questions that may come up. So back to the slideshow. Now we're going to talk about distribution documents or dispositive documents. And these are the ones that most people are thinking of when they come to see me. They pass your assets to your heirs or your beneficiaries after you're gone. So the two main types of documents are wills and trusts. And I'm going to explain the details about each of those things. So what is a will and what does it do? There are two main types of wills. There is a simple will, which is what most people are thinking of when they come to see me. It will put in there who you want to get your things and who you want in charge of those things. So it's going to nominate an executor, and it's going to say, I want all my kids to have everything split equally between them, if that's what you want. The key that some people don't understand about a will is all wills must go through probate. That's the court process. So all wills are supposed to be submitted to the court. Even if you don't need probate, it's technically your will is supposed to be submitted there and said that no probate is necessary. But some people don't do that because there aren't really any repercussions for not submitting it. But that's a simple will. The other type of will is a pour over will. So that is a document that's used in conjunction with a trust. It's a backup document. The hope is it's not going to be necessary because you've gotten everything inside of your trust. And I'll explain what I mean by gotten everything inside of your trust as we move forward. But the only beneficiary of a pour over will is your trust. And it's there to pour any asset that you still left in your individual name and didn't get into your trust by pouring it over. Both of these documents are where you are going to nominate guardians for your minor children. And you're, usually going to say my spouse first, and then you pick, if you're both gone, who you would want that to be. Some important limitations on a will. What does it not do? It is often surprising to people when I tell them a will does not give your executor the authority to act. It's a nomination only. The only way that an executor gets the authority to do that job is through a certificate of appointment that is granted by the court in your county of where you passed. It does not avoid probate. A will is a probate vehicle, so it will have to go through the court process. It doesn't control assets that have beneficiaries. So things like your IRAs or your life insurance, or even bank accounts that you have made a TOD or a POD payable on death transaction or account designation will not go through probate. So you can avoid probate in that way. It also doesn't control jointly owned property with rights of survivorship. Most things, like in a joint account, when somebody passes away, the survivor is going to own that property on their own. So when you have a husband and a wife and they own everything jointly, not too much needs to happen when the first spouse passes, because a lot of times it's very easy. The joint owner receives everything automatically and no court is required. It just happens by process. But it's after both of you are gone that probate comes into play. A will does not manage, protect, or structure inheritances beyond naming beneficiaries. So it's limited in what it can do. It also does not generally provide age-based or maturity-based distribution planning for minor children unless you put a trust inside of a will, which kind of defeats the point of a trust, because one of the main reasons for trusts are probate avoidance. So putting one within a will is generally not going to be your best bet. So that brings us to trusts. What is a revocable trust? You're going to see there's a little picture of a box of apples, and that's because I say a trust is a metaphorical box for your assets. You're the grantor, that's the person who creates it. You're the trustee, that's the person who's in charge of it. You're the beneficiary during your lifetime. So everything is there for you and on your behalf. It can be changed or revoked at any time. That's the name revocable, and why we include the name revocable generally when we write our trusts, or sometimes it's called living trust. You can add or remove assets to it at any time. You maintain full control over the assets during your lifetime. I have a lot of people concerned about losing control of their assets if they put it in a trust. And I think that's because a lot of people confuse revocable trusts and irrevocable trusts. An irrevocable trust means you lose control of an asset. And I will briefly discuss irrevocable trusts at the end of this, but most of the time, what I am doing for people is a revocable trust, and it's there for probate avoidance. It does become irrevocable upon either your death or, if it's jointly held, both deaths of the grantors and trustees. So it's for the benefit of the grantors, the two people usually that create it during their lifetime. So some basics of a revocable trust. As I said, you're the grantor. That's the person who is setting up the trust. So you can have one grantor. If you're single, you can have multiple grantors. If you're married, you don't necessarily have to have a joint trust if you're married. Some couples have their own trusts, and that can depend on how they hold their assets. And another main reason could be for tax purposes. But most people aren't concerned with taxes because the federal estate tax exemption limit as of today is $15 million per person. So that's $30 million per couple. You are also the trustee. So you're the person who manages the assets in the trust until you resign or you can't act. So a trust is also useful during your lifetime if you or both of you become incapacitated. It allows for successor trustees to have access immediately to whatever assets you have placed in your trust. You're also the beneficiary, and you fund your trust during your lifetime with the vast majority of your assets. I'm going to talk a little bit more about what I mean when I say funding your trust in a few minutes. Your trust is only as valuable as the assets you're going to title therein, and it will only avoid probate to the extent you fund your trust. So any asset that you don't fund into your trust, and it is a retitling process to get an asset into your trust, is going to end up having to go through probate, and that pour over will step in and allow the assets to be poured into your trust. Everything in the trust is to be used for you, by you, in any way that you choose during your lifetime. So again, some people are really concerned about the control. Nothing about how you own assets that are in a trust is going to change. They are still completely yours. And you can take them in and out of the trust at will. When you're gone, your successor trustee is going to distribute your assets per your distribution plan as outlined in the trust without court oversight, as long as there's not a contest of some sort. So that successor trustee is given the benefit of not having to run under the court's rules, under their deadlines and their guidelines. How does a revocable trust work? Well, as I was talking about the funding, it is you get your assets retitled into the trust. So you place your assets in a trust and it removes it from your individual name and puts it into the trust name. This is going to allow your assets to pass directly to beneficiaries, avoiding probate. The trust is going to rule it. It's once something is retitled into your trust, then the trust is in charge. If it's not in your trust, then it's going to go through probate and the court's going to be in charge. That doesn't mean the court's going to take your assets. It just means you're going to have to follow their rules to get the assets to your beneficiaries. So the trust rules and your assets are going to be distributed to your beneficiaries according to the instructions. And it gives you the control over how and when they receive them, because you can put in provisions in your revocable trust. So what do you put in your trust box? What goes in the trust? So assets that most people put into their trust, their home. So that's something, when somebody comes to me to do a revocable trust and they own a home, we also do a real estate deed at the same time to get that home titled into the trust. And the way that happens is it goes from their name as John Smith to John Smith, trustee of John Smith's revocable trust. That's the retitling process, and that's how the trust ends up controlling it. Then you also put your tangible personal property in it. That's basically everything that's in your house that doesn't have a title: your clothing, your furniture, your animals, um, all the stuff that you have accumulated over your lifetime. You're going to sign off on a little piece of paper that says, I deed all of my personal property into my trust. And that way, whatever you buy and sell is automatically inside the trust. So you don't need to update your trust just because you bought a new purse, because that would be really unmanageable. Bank accounts. Checking and savings is very common. Credit union accounts, and motor vehicles that are paid off. We don't generally recommend that you put motor vehicles that have a lien on them, because there's usually a difficulty with the lien holders. They don't want to give over title to something because they still have title over it. So assets that are not usually in your trust box: retirement plans, 401ks, and IRAs. We almost always recommend our named beneficiaries as individuals. So most commonly, if you're married, you name your spouse, and then some people don't think of it, but you should always have contingent beneficiaries. And if you have children, those are the most common contingent beneficiaries, but you can name anything. You can name a charity, whatever you want to put as a beneficiary there. Annuities also do not generally go into a trust. Transfer on death, because remember, those have beneficiaries, so they're not going to go into a trust. Health and medical savings accounts, they are a different type of account, and they generally don't go into trust. And as I already said, cars that have liens. Well, I think you probably have picked up on some of the benefits of a revocable trust as we've gone through this. But first, I think most important benefit is that it avoids probate. The assets are going to pass directly to the beneficiaries, and it bypasses the public and the time-consuming probate process. You retain control. So the trust is revocable, and it can be changed or terminated as your life and circumstances evolved. You're going to be able to amend that trust at any time that you want. And it's similar. You can change your will too, but people do worry about that loss of control, and you still are able to control everything. Another big important point about having a trust is it can maintain privacy. So wills going through probate court. Probate court is a public forum. Those documents are available to anybody who wants to access them, whereas a trust is generally only accessible by the beneficiaries, to the extent that they have the ability to call for a copy of that trust. This can reduce family conflict. It provides a clear roadmap. A trust is generally a very thorough tool to help minimize misunderstandings and disputes. It also has flexible beneficiary planning. This is another great benefit. You can place conditions on your distributions. You can kind of protect assets for minors or manage the timing and access of that. One of the things that some people are concerned with is, their child has a tumultuous relationship with their husband or wife, and they don't want them to have access to the assets that they're going to leave to their child. So you can hold those things in trust and not give them out immediately if that's a concern, and give the trustee the discretion. It's really important if you have property in another state. So if you own real estate in another state and you don't have a trust, then you have two probates. So that takes a somewhat difficult process and multiplies it. And I don't know about other states' probates. New Hampshire makes its probate pretty reasonable. but it lacks privacy and it's under the court's rules. So it's fine if neither of those things bother you, but a lot of people opt for a revocable trust. Now, a revocable trust does have limitations, and this is really important. It does not avoid taxes, and it does not qualify you for long-term benefits. Because it's revocable, all the assets are yours. So this is a common misunderstanding I have with people when they come in to see me. They say, well, I've got my house in trust, so it's protected. That's not the case. If it's a revocable trust, it's your asset and it does not protect it during your lifetime. It can protect it in the circumstances I just described with, say, a divorcing child. It can protect assets in that respect by holding things in trust. But for your creditors, your revocable trust is available to you. You have the ability to change it. So you own everything that's in there. It only works if you properly fund it. So sometimes I have people come to me who have gotten trust before and they weren't given instructions on how to fund it, how to retitle. So when people come to us to do their trust, we give them a detailed letter that is going to give instructions on how to get each asset into your trust. We give you one of the ancillary documents to a trust is a certification of trust. And that's a document that you bring to the bank or to the town clerk when you're trying to get your car in or your bank account. So it's really important. The whole point of probate avoidance is nil if you do not get your assets into the trust. It does cost more upfront and it requires more maintenance. So that is, I think, probably the most common reason that people decide not to move forward with a trust. And it doesn't replace incapacity planning by itself. Just because you have your assets in a trust, there are still some things that might be very difficult for somebody to handle financially. So you still need your powers of attorney, and it doesn't do anything with regard to your healthcare decisions. Another thing is sometimes banks are difficult when dealing with trusts. Most are familiar, but banks can question how who's in charge of the trust, and sometimes you end up having to do something like a affidavit that you're the trustee, and things of that nature. So I'm going to briefly cover irrevocable trusts. I don't do irrevocable trusts, and most people don't want them when they understand the cons of having a revocable trust. So what it is it's also like a metaphorical boss that holds your assets for designated beneficiaries, just like a revocable trust, but it can't be changed without consent of the beneficiaries. You have to give up ownership and control. And it does remove your assets from your taxable estate. That's one of the reasons that somebody would have an irrevocable trust. If they have a taxable estate, they have more than $15 million and they want to be under that exemption limit, they can get an asset out of their estate by putting it into an irrevocable trust, because then the asset isn't theirs. And so it won't be counted when they pass away towards that exemption limit, because they gave it away during their lifetime and put it into an irrevocable trust. Why are irrevocable trusts used? Just as I said, estate tax reduction, if properly done, asset protection, Medicaid planning, but you have to take into consideration the 5-year look back period, which is another reason that people don't always want to do an irrevocable trust, because there's the chance that in that 5-year period, they could end up needing nursing home care, and they've put their assets into an irrevocable trust and the assets are no longer theirs, but they haven't met that 5-year look back. So the asset's countable as though they do own it, which puts you in quite a pickle. And it also provides, just like the revocable trust control after your death. So the limitations are that loss of control. You can't take the assets back. You can't freely change the beneficiaries or the terms of the trust. It's essentially permanent and has limited flexibility, and it's probably going to require a separate tax return and extra costs. So they generally are going to end up being more expensive than a revocable trust because of the nature of what they do. When it makes sense is special needs planning. That's the one place where irrevocable trusts, we do actually do those. So we do special needs trusts. They're usually revocable upon creation, but they become irrevocable once they are funded beyond a nominal amount. And that is, again, to protect the assets that are in there for the beneficiary that is on government aid, whether it's SSI or Medicaid. So you need it to be, if there's assets in there, it's got to be irrevocable for it to be able to not be counted towards government assistance. Another time it makes sense is if you don't need the asset. If you don't need it, I mean, most people need the assets that they have. But if you don't, then an irrevocable trust may be something you want to consider. If you're planning really far in advance. So again, remember that 5-year look back period with Medicaid. Some people are thinking about it when they're, in their retirement years, and that's really not a good time to consider doing an irrevocable trust. And usually before that period, you're not ready to give it up. So it's a difficult thing. If you are, if your main goal is asset protection or tax planning, then an irrevocable trust makes sense in those circumstances. If you are comfortable relinquishing control, you say, well, I'm not concerned about it being mishandled, and I don't mind if somebody else controls it. Estate planning. So why do it sooner rather than later? I mean, I think it kind of, the information I've given you here has kind of implied why you would want to do it, but it's obvious that life is unpredictable. Nobody can predict when they're going to get into an accident or if they're going to get ill and other unexpected events. Estate planning is my favorite thing to do. Clients do share when they leave that they feel lighter coming out of the office after their planning is done. It's a relief. I think of estate planning very similar to life insurance. It's not quite the same thing, but the benefit is for your loved ones mostly, although a trust is also a benefit to you during your lifetime. So it's kind of even better than life insurance. Getting this done encourages these conversations to occur during your lifetime. When you are gone, it's already going to be a really difficult time for somebody. Or if you're incapacitated and you're ill and you need powers of attorney, that's going to be a really difficult time. So you want these things in place so that your family has the ability to help you and knows what you wanted. It also gives you control. If you don't have powers of attorney in place, for instance, you're not going to get to control who goes to get a guardianship over you. The court's going to obviously have a hearing and make sure that that guardian is a good choice, but you're not going to be able to pick. And if you don't have a will, the state decides where your assets are going to go. It doesn't mean it's going to the state. That only happens if you have no relatives past the point of a 5th degree of kinship. So it's going to go down in order, but it might not be the order that you wanted, depending on your family dynamics and how you have what you have for a plan. It avoids panic during a crisis. So whatever that crisis is, whether it's a health thing, an illness, an accident, or a death, this helps people feel like they have some guidance. They know what they need to do. One of my main reasons for people getting it done sooner is capacity. You need to be capable of executing these documents. So if you're in a place where you're permanently unconscious, you can't execute a power of attorney. If you are in an advanced state of Alzheimer's or dementia, you don't have the capacity to sign off on these documents, and that's when you probably need them the most. And early planning helps avoid probate costs and court-appointed guardianships and other expensive mistakes. So it really, I know a lot of people say, well, I don't need an estate plan yet. I don't have an estate. I don't have things. But even if you don't have things, you should still get your powers of attorney in place, because um, that's something that even a graduating high school student can use and can be important for parents, because you don't have the ability to make healthcare decisions anymore, um, with the exception of the surrogacy for a temporary period of time. You can have a surrogacy in place. Now, let's say you do have your estate plan. When should you review it or update it? A rule of thumb is every 5 years you should look at it. But really, the most important time is to review it when there is a major life change. You got married, that you've gotten divorced, somebody was born. You want to make sure that they're mentioned in your documents, or somebody has died, or somebody has become incapacitated. So another time that you might use it is when there's changes in the law. That's not a very common reason. Usually, even if there are changes in laws, they take into consideration that somebody's document might not be as up to date as that. And usually they will, be able to make it work for its purposes. If you have legal or financial changes, like if you change your tax bracket, you might consider doing some more estate planning. Moving is an important thing. So if you have your estate plan in New Hampshire and you're moving, I'm going to tell you to go to an estate planning attorney in the state that you're moving into, because we're all different rules in different states. These are made so that they should be good in the states, but sometimes states have really specific rules that you might want to update or amend to include a provision that is required by that state. And then it kind of goes without saying, but if you wouldn't feel 100% comfortable with the documents being used tomorrow if they were needed. So those are all signs that it's really time to look at your estate plan and take care of things. Well, I've got my Q&A open. I don't see any questions, but I'll hang here for a few minutes. Oh, no, oh, and there are questions. Why did that not show up before? Okay. Oh, what does a revocable trust typically cost? And does an attorney need to draw up a living will for it to be legal, or can you do it on your own? Two very different questions. Revocable trusts, it's hard to say what they cost because it depends on if you're an individual doing it. An individual trust costs a certain amount of money. A joint trust costs more. Do you need a deed with your trust? Do you have other documents in place? So when somebody asks me about, well, how much does a trust cost? Well, the trust itself might not cost too much, but all the stuff that you're going to end up needing with it, you're going to need an overall plan. And so, you're looking at a few $1,000s, and it just depends on your circumstances. So it's really, it's hard to pinpoint, and I don't give, an idea of that until I meet with you and I go over your particular circumstances to know if there's any special considerations, because you might have extra things that need to happen in your trust that are gonna, end up adding cost to it. An attorney does not need to draw up a living will for it to be legal. You can do it on your own. In fact, a lot of doctors' offices and hospitals will have um, a form that allows you to do a healthcare power of attorney and living will on your own. You just need to have it notarized, or you need to have two witnesses. When we do ours, we have it both notarized and witnessed. So, oh, okay. And so I hope that answers your question. If not, you can write in another question. The next question is, if you put an IRA or a 401k into a trust, wouldn't the beneficiary receive the funds anyway? So why the trust? So I don't recommend it if the beneficiary is over the age of 18 and responsible. The reason you would put it through trust is if, for instance, you have minor children and the funds are going to be held in trust. A minor child can't take from an IRA. So if you name a minor, then it's probably going to end up going through probate if the trust isn't named and held and handled in trust until the child is old enough to receive it. And another reason that you might want to put it in an IRA or into a trust is because you have spendthrift concerns. You have a beneficiary that is not good with money, that is going to blow that money right away. And you want to make sure that it's handled that way. There are tax consequences to putting these things through trust. So you have to take those into consideration and, speak with an accountant or a CPA on the possible impact that it can have. So let me know if that does not answer your questions. And I'm looking and I see those. Does it make a difference if there are liens on any assets, a house, a car, etc.? Can a trust still work? So the car with a lien, we don't recommend you do that. I don't know that you would even be allowed to do it by the lien holder, because it's not really yours to retitle. Once you have the title in your name, you can do it. A house is very different. Many people come in with a house that has a mortgage on it. So it's perfectly acceptable to put your house into a trust, even if you have a mortgage. There is actually case law that provides that you are allowed to do that without them, being able to do a due on sale clause or accelerate the payment of it. So we recommend that if you have concerns, that you reach out to your mortgage holder, but you have the absolute right to put that in there. And so that's a great question. It does make a difference for certain assets like the car, but with a house, it does not. Somebody said thank you. You're welcome. Thank you all for coming to this and listening. I really I love talking about estate planning, even though people probably don't like listening to it too much. Because it's just something that everybody really needs. And like I said, people feel great when they get it done. And I really love doing what I'm doing. And so if you have any questions, you can certainly email me, call the office, and make an appointment. And I'd be happy to discuss things further. Remember, this is not legal advice. This is just legal information. You're welcome. So I would not give you advice unless I know something more about your specific situation. But what I'm telling you is basic knowledge that most people don't have because this is not their area, but it's mine. So with that, I think I have gone through all of the questions. So I'm going to end this event and thank you again for attending. Have a good night.